Now, this has gone to the cabinet. This has gone to the cabinet, and then your lordship, the first page.
I will just clarify the position. I'm also online.
Please wait,
Yeah.
Mr. Learned Advocate General. Mr. Iralu, what is the subject matter about?
Your Lordship,
What is the subject matter about?
subject matter is about the jurisdiction of the present regularly constituted courts in terms of the direction given in Registrar General's case, General Registrar General's case, pronounced in 2013.
No, the subject matter in the present case is regarding appeal from.
Yes, appeal from
from?
decisions rendered by the village council, GBs or DBs.
To which forum? To
To
which
which
forum the
forum?
appeal will lie?
Yes, because in
Yes,
terms of-
Learned Advocate General,
Please, sir.
the documents you have submitted is silent on the issue
Sure.
raised in the present writ petition.
1 minute. We have constituted the committee. Committee has given the report, as I had said many times yesterday. And the report will reach finality after the law department submits it to the cabinet. So I had specifically mentioned yesterday that since this report has to be finalized by the law department, which will give it to the cabinet. Once that is done, then I can place it on record. This is at that stage today. And with what is the appellate portion, what are all these things, they'll be revised by the law department if required. And once that is done, that will be clear. We will do it maybe by.
Learned Advocate General, kindly,
My
see,
lord. Sir,
this is regard, the issue, on the papers is
Yeah.
regarding the enforceability of chapter 4A.
correct.
Chapter 4A.
That's right.
Here, actually, we are faced with an issue as to which of the forum appeal will lie against the judgment passed by the village council court.
It's correct. So that report will indicate everything which they have submitted. That is why I said, once that report is approved, I'll
Can you
place it before the court.
kindly give one of this to Mr. Hiralu, the learned.
Yes, I have received.
Yes.
Okay.
I've given it to him.
The
So
only
that will
thing
be,
is,
we have, in fact, this matter was argued on this
whether
very point, and we had not,
enforcement of
and we had
chapter
not
4A
gone into any
will solve the
adversarial
problem or
litigation.
not. That is the only question
Yeah.
now.
That is why I am actually
Yes.
putting that question.
That-
Yes,
So we are solving that very issue. That is why I had myself appeared in detail. We had argued this matter. It is not an adversarial litigation. The grievance was correct. Therefore, we had to address that grievance. And in the light of that, the committee was appointed.
Mr. Advocate General, you are well aware of the fact that actually, unless this issue is resolved,
Correct.
the question as to whether an appeal will lie before the statutory court will be kept hanging. And we
Correct.
should allow that.
So that will be rooted by next, within another 3 to 4 weeks. The matter will be over. That's what I was saying. The matter will be over. So everything will be addressed. We are aware of this. We are conscious of this.
Do you mean to submit that the issue raised in the present writ petition will also be solved?
That it should be solved.
Which I do not find in the records, which have.
It will be solved. Everything will be solved to the satisfaction of justice and law. There shouldn't be any problem on that. There should not be any doubt on that. That is why whatever report they have given, they will submit it to the law department. If at all there is any inadequacy, we will do it. But I don't think so there is any inadequacy.
This is
So
regarding, this is regarding enforceability of chapter 4A of the
Correct,
Rules for
correct.
Administration of Justice and Police in Nagaland.
That's right. So
Maybe
therefore,
the issue raised in the present writ petition can be solved only
Yes.
by the government enacting a civil court.
yes.
correct. So therefore, that is why it has been given to the law department. And by next month, their whole
Law department, the issue which has been referred to the law department is not as to whether it is not on the issue of the constitution on the enactment of the civil court act.
In fact, the report gives the details what are required. And whatever has to be done will be done by us within 4 weeks. That's what I'm trying to submit. We know what is the problem. We understood the problem. and we want to find a solution. It is precisely for this that we refer the matter to the court, I mean to the government, and then they went in detail. Cabinet also acted quite fast, and now it is before us. If there is any inadequacy whatsoever, we will sort it out, because this is definitely an issue.
We give you 4 weeks' time.
Yes.
You take
Give me
necessary
five
action.
weeks, 5 weeks.
Kindly listen.
Please.
If not, this
Let us not-
will give a judicial pronouncement on the
Let
reference.
us not get into that at all. When I'm saying that we will do it, we will do
No,
it.
no. No,
Give-
we will accept your submissions, but at the
Yes.
same time, you cannot actually keep the matter hanging.
We are not going to do that. That's why I'm making the statement. I'm making the statement. What more is required? Please tell me. We'll do it. It's not adversarial at all. It's a genuine grievance as to where the appeal lies. That is, there's no
why
true
We will
opinion
give
on
you
that.
4 weeks' time.
Give
If
me
not,
5
if
weeks.
no instruction is placed, we will pass a
Please.
judicial order.
Please give me 5 weeks. 5. If it's possible, kindly give me 5 weeks. Need not mention judicial order. The court is always free to pass whatever order is required.
We mentioned judicial orders.
I am saying
No
that
instruction is placed. We cannot allow this.
I
thing
am telling,
perpetually.
I am making a statement, this matter will be solved. I made a statement when
We
the
take that into
209
account. We take
officers
that
were
into
to be
account.
appointed.
We take that into account.
That's
But
it. So
we also make it clear that if no instruction, clear instruction is received,
I am just
we pass
saying that
judicial orders on the
you
reference.
can only say no further time will be given appropriate time. So it's over. What is that? This is not adversarial litigation. It is something which pertains to all the legal fraternity itself as to where the appeal lies. So why should we keep it hanging? It will be over. Give me 5 weeks and it will be over.
Weeks, mentioned. About 5 weeks.
Mr. We give 5 weeks.
You know,
After that, we pass judicial orders.
yes.
Maybe we will appeal. Not required, we'll do it.
Mr. Ari Raghu. You're for the petitioner,
Yes.
Mr.
Limo also is there. Yes.
Civil Division? 5. What about the other civil division? 6.
Yes. In that, I'm the petitioner.
Okay. Okay, Mr. R. Iralu, the learned senior counsel, assisted by Mr. L. Iralu, the learned counsel for the petitioner. And Mr. L. Iralu and Mr. Limawaba, the learned counsel for the petitioners. Also heard Mr. B. N. Balgopal, the learned Advocate General, assisted by Mr. Mua Imchin, Learned Senior Government Advocate.
And,
And Nitya Nambiar,
yeah, not here.
Nitya Nambiar, NIT.
No, Learned additional Learned Advocate General, assisted by Mr. Mua Imchin, the Learned Senior Government Advocate, and Miss
Nitya
Nitya Nambir
Nambiar.
for the third respondents, as well
So-
as
Malacha, for respondent number 2 in civil revision 6.
Mr. So-and-so,
Forty-nine for the respondent number
the
five. and
Learned
six.
Council for their respondent number
4 and 5.
six,
In civil-
Respondent number 2 in civil revision 6,
respondent
Of
number
2002.
in civil number 6 of 2002.
21.
2021, as well as Mr. So-and-so,
4 and 5.
Learned Council for the respondent number 5 in civil revision
5.
5
Yes.
of 2020. 2020. As stopped. Ordered by us on 16/10/2024. The Learned Advocate General, Nagaland, has placed the minutes of the cabinet meeting held on 9/10/2024, comma, the order dated 23/8/2024, passed by the Commissioner and Secretary to the Government of Nagaland, Department of Law and Justice, Nagaland, Kohima, comma, the letter dated 10/9/2024, written by the Commissioner Nagaland to the Commissioner and Secretary, Department of Justice and Law, Nagaland, Kohima, and the report of the Committee on Customary Court as per Chapter 4A of the Rules of Administration of Justice and Police in Nagaland, 1937, within bracket Third Amendment Act, 1984. Stop. New para, a perusal of the records placed before this court shows that the issue is with regard to the examination of Chapter 4A of the Rules of Chapter 4 of the Rules for Administration of Justice and Police in Nagaland, 1937, within bracket Third Amendment Act, 1984. Whereas the issue raised in the present writ petition is with regard to
Appeals
the forum
forum
against which,
against the orders of
against,
village council, GBs or Dubashis,
against
village authorities.
the forum to which an appeal will lie against the orders
Orders,
passed by the village authorities.
yes.
Stop. Mr. A.G. Balgopal, the Learned Government Advocate, the Learned Advocate General, however, submits that the records which has been placed before this court today will also solve the issue which has been raised in the present writ petition, and therefore submits that 5 weeks' time may be granted to the state respondents to resolve the issue. On the subject raised in the present writ petition. Stop. The Learned Advocate General Nagaland is accordingly granted 5 weeks' time to place the decision of the government on the records placed before this court today. It is made clear that if no instruction is forthcoming on the next date fixed, this court will make an endeavor to resolve the issue by passing a judicial order on the
20,
reference met before this court.
yes. We can fix on 20 November, 27, 5 weeks.
Yes,
Okay.
Mr. Leonard, Advocate General, any date, we are giving you 5 weeks time.
Yeah, what is the border case?
22nd and 25th.
25th, huh?
27th, they are asking 27th.
20, August 28th.
25th, 22nd and 25th.
What day? Can I just get back?
Yes, yes,
I-
please.
We will inform the date to my little colleague
Yes,
there.
please.
We'll mention to. Just because we are having the Assam Nagaland border dispute in that
Correct,
time.
correct.
I will
So,
just check that. I'll get it
Your
back
convenience.
just in 2 minutes. I will get back. I'll mention, my learned colleague will mention it to the date. What's the date? What date to the border?
22nd and 25th.
27th is okay. 27th is okay.
So 29, 28 we have Prakriti sir. The 28 was
28th.
less Prakriti sir. So we'll reward.
28th.
Yes, sir.
What is the first week? 20?
27th, 25th, we have border. 28th, we have 25th.
We'll get it on 20th. Well, can we have it on 20th if it's all right?
okay, okay.
20th. Right.
Listed on 28, 11.
20.
20.
Thursday,
20.
Ah,
28 is Thursday.
20th.
it's all right, it's all right.
Yes,
Right.
of course.
Listed on 28, 11, 20,
20th. 20.
20,
Yes, yes.
0, oh, 20.
Yes.
20, okay, okay,
20,
okay.
listed on,
Yes, yes, yes.
okay, listed on 20, okay, 20, 11, 20, 20.
So,
Stop. The records placed by Mr. Moimchan, the Leonard Senior Government Advocate, before this court shall be placed on record.
Lordships, may I mention that the main counsel for respondent number 2, Mr. Kakrimulia, he has accepted a new assignment given by the government. Therefore, his name may be deleted from this case, Lordship.
In which case,
Civil Revision 6 of 2021. Civil Revision 6.
Civil Revision 6,
Yes, Lordship.
the registry shall take steps to delete the name of Mr. Kakrimule as the Leonard Counsel for the respondent number,
Respondent number 2 in Civil Revision 6.
as the respondent number 2 in Civil Revision 6/2020. Okay.
Obliged, Lordship.
Bless you, Lordship.
May I please, your lordship?
Yes, Mr.
Lordship, I beg to mention item number 34, lordship. 34. Lordship, I pray that this matter can may come up after 2 weeks.
On the prayer of Mr. V. Jamogi, the learned government advocate. Listed again after 2 weeks. Annual.
May I please, lordship?
Yes, Mr.
Lordship, I beg to mention item 34, 33. 33, I'm for the petitioner. Lordship, here my senior has some personal difficulties. So if the matter can come up to 3 weeks, lordship.
Mr. Seko Putin, the learned counsel for the petitioner, seeks adjournment of the case for 3 weeks on the ground that Mr. P.P. Paul,
Lordship,
the leading counsel, is indisposed.
lordship indisposed.
Yes, so. Prayer is allowed, listed accordingly. Okay.
Lordship is an interim. Kindly continue, lordship.
The interim order passed earlier shall continue till the next return.
Much obliged, man.
Yeah.
Your Lordship, I beg to mention item number 32. Your Lordship, I have sought for certain clarification here, so kindly let the matter come up after 2 weeks.
MS, the learned government advocate submits that he has sought for certain instructions, which is yet to be received, and therefore seeks adjournment of the case. for
After 2 weeks. Lordship,
There is a law listed accordingly.
My lord, I beg to mention item 35. My lord, I have received this instruction just recently. May I pray that 2 weeks' time may be granted to file my affidavit,
Mr.
additional affidavit.
Mr. L.T. Sankar, the learned additional advocate general submits that he has received the instructions and will be filing additional affidavit, and therefore maybe there is a law.
Much.
Listed accordingly. Kindly, you are disturbing the court. You are disturbing the court. The learned counsel. Yes,
May I please, my lord?
yes.
Lordship, I beg to mention item number 40 and 41. Hearing item 40 and 41, my lord.
Is it 39? Just see.
WPC 136 and 137, my lord.
Item?
Hearing item 40 and 41.
No, it is 37, 38.
Lordship, 37. Lordship,
37, 38.
Lordship, I have another cause. Lordship. Anyway, Lordship, adjournment for that. Lordship, 37, 38. Lordship.
I think you are sleeping. Well, there's a new post was printed. 37, 38.
Lordship.
Yes.
Lordship, I'm extremely sorry. I'm not ready with these two matters today, Lordship. If some time can be granted.
Okay, Mr. N. Angami, the learned senior government advocate, submits that he is not ready to argue the matter today and therefore seeks for a week's time. Prayer is allowed, listed after a week.
Deeply obliged, my lord.
Yes,
may I please, Lordship.
yes.
Lordship, I beg to mention hearing item number 31. My senior has some personal difficulty today, Lordship.
Who is your senior, ma'am?
And
And
Mosai,
Mosai.
Lordship.
31.
Lordship.
What is the matter? What is the matter, ma'am? Yes, I'm asking
Lordship
you.
is regard to pension.
Pension.
Yes, Lordship.
You have not received your pension
Yes, Lordship.
or N Muzui. MS. So and so. Makes a mention on behalf of N Muzui. The Learned Counsel for the respondent number
6, Lordship.
6 and 6 adjournment of the case for
2 weeks, Lordship.
2 weeks. On what ground?
There's some personal difficulty.
On the ground that Mr. N Muzui has some personal difficulties. Prayer is allowed, listed accordingly. Okay.
Lordship.
May I please, Your Lordship?
Yes, please.
Lordship, I beg to mention item number 37 on behalf of counsel for the petitioner Asang Lawali.
37 has been mentioned. 37 has been mentioned.
36, my lord. Apology, my lord. 36.
36, yes.
Yes, Lordship.
Yes.
Lordship, I pray that its matter may be listed after 2 weeks. She is out of station, my lord. Counsel for the petitioner.
You're here for the petitioner,
My lord, I'm appearing on behalf of counsel for the petitioner Asang Lawali.
Mr. A. Chishi. Correct.
Yes, Lordship.
Learned Counsel makes a mention on behalf of Mr. M.S. Asangla Wali. Learned Counsel for the petitioner and seeks adjournment of the case. for
2 weeks,
2
Lordship.
weeks on the ground.
She's out of station,
On the
Lordship.
ground that M.S. Asangla Wali is out of station. Prayer is allowed, listed accordingly. Okay.
Obliged, Lordship.
Yeah.
May I please, Lordship? I beg to mention item number 44 on behalf of S. Chan. Lordship, if this matter will come up after 2 weeks.
M.S. Pichano, the Learned Counsel makes a mention on behalf of M.S. Chang, the Learned Government Advocate, and seeks adjournment of the case for
2 weeks.
2 weeks. Prayer is allowed, listed accordingly. Okay.
Are you pleased?
May I please, Your Lordship?
Yes.
I beg to mention hearing item 43. I believe this matter may be listed after 2 weeks.
You are for
I'm for the
Petitioner.
petitioner,
Mr.
Benison Visual.
Mr. So-and-so,
Your Lordship, 42, item number 42. I'm sorry.
42. Mr. Benison V. Shohei, correct?
Yes, Your Lordship.
Learned Counsel for the petitioner seeks adjournment of the case for
2 weeks.
on what ground?
Personal
On
difficulties.
the ground that the Learned Counsel is having some personal difficulties. Prayer is allowed, listed accordingly. Okay.
Obliged.
This, your Lordship, I beg to mention for item number 40 and 41. Lordship, my senior has some personal difficulty today. Kindly list.
40 and 41.
Yes, Lordship.
40, so also 39, 40, just see.
Yes, Lordship, WPC 280 and WPC 212.
So it is item 39 and 40,
Okay, Lordship.
item 39 and 40, okay?
Kindly list the matter after 2 weeks.
You are, madam, you are having this cost list, no, same cost list. Item 39 and 40. MS, your good name?
Vikono Kiso.
MS Vikono Kiso. Learned Counsel makes a mention on behalf of Mr. Imti Longchar
Yes, Lordship.
and seeks adjournment of the case for 2 weeks.
2 weeks.
Prayer is allowed, listed accordingly. Okay.
Much obliged.
For motion item number 1.
Yes, what is
May I please, Your Lordship?
the case?
Lordship, this instant petition is filed challenging the judgment order dated 16/4/2024 passed by the Dubashi Customary Court.
Which is that page?
It's at page 49,
Page?
49 and 50, annexure N, Your Lordship. Your Lordship,
Just read this. Is it a dispute between the husband and the wife?
yes, Your Lordship. The matter arose out of a matrimonial issue between the husband and the wife. That is the petitioner and the respondent number 2. Both the petitioner and the respondent number 2 are from different tribes and from.
Respondent number 2.
Yes, Your Lordship.
And who will be the respondent one?
The government, Your Lordship, Deputy Commissioner Siminu.
Who has passed this order?
The Dobashi Customary Court Siminu.
Will Dubashi not be a necessary party? Yes, Mr. Taka. In a case decided by the Dubashi Customary Court, only the deputy commissioner is implemented, whether the Dubashi should be implemented as one of the parties?
And that since if it is, if the Lord, if the Dubashi's court had Dubashi's had decided as a court, or in whatever, in which capacity, Lordship?
They have, this is a judgment order. Not passed by the Dubashi's court.
My Lord, in the respectful submission, court should not be.
Okay, okay. Proceed. What was decided?
Lordship. Lordship, it is at page 46 annexure and
Page
the relevant,
46.
yes, yes, the relevant page is at page 49, Your Lordship.
I am on that. So
Uh,
what the Dubashi's court has decided? I still am not able to.
Yes, Your Lordship, the Dobashi court has decided, the land in favor of the respondent number 2, Your Lordship.
So long as come on. Reading the. Are they divorced?
No, Your Lordship.
They are not divorced.
Yes, Your Lordship.
So this order only says that so long as the respondent number 1, respondent number 2 is alive, she will have the legal right to stay in the house.
Yes, Your Lordship, but the respondent number 2.
It is not giving away to the respondent number 2.
Yes, Your Lordship, but the respondent number 2 no longer wants to live with the petitioner. So in regard to this, the petitioner has filed an appeal in the Lazami Village Council, Your Lordship.
Lazami Village Council?
Yes, Your Lordship.
How was it possible?
Your Lordship,
You are going down backward.
yes, Your Lordship.
Yes, Mr. Joshua.
It was perhaps an oversight on the part of my junior colleague, but it's actually not an appeal, but Lazami Village Council. Your Lordship, this is an issue between 2 tribes. Customary law of one tribe does not apply on the other tribe. So the wife is from Rengma tribe.
This is the Minyo District Customary Court.
Yes, Your Lordship. And the petitioner is from Lazami village. So, my Lord, naturally, according to the Naga customary practice, once a lady is married to a man, then the customary law of the man will apply. Here in this case, Your Lordship, the twist is that the customary law of the wife who has taken the identity of the man is applied on the man. So, Your Lordship, he was not even interested to appear before the Rengma customary court at Seminyu. But my Lord, they took his statement, but as far as the allegation is concerned, nothing was cross-checked. Just the statement given by the wife, the ex-wife now, Your Lordship, that was taken as a gospel truth. And the order was passed. Even though the judgment and order was also not made known to the petitioner, he came to know at a later stage. So he wrote to the additional deputy commissioner at Seminyu for intervention. But my Lord, the same was not done. Hence this petition, Your Lordship.
Mr. Joshua Shakti, the learned counsel for the petitioner. The present writ petition has been filed. To caution set aside. The judgment and order, the judgment order dated 16/4/2024,
my lord.
passed by the Dubash's customary court.
Uh,
Correct.
more particularly, Rengma customary,
Court
yes,
within Rengma's customary court.
my lord.
It's a menu.
Yes, your lordship.
It is submitted that the Dubash's customary court at Seminu did not follow any procedures for passing the judgment order dated 16/4/2024. It is further, it is further submitted that the district customary court, the Dubash's customary court, Seminu, does not have the jurisdiction
My lord.
to decide the issue between the petitioner and the respondent number 2. Correct?
Yes, my lord.
Issue notice to the respondents. Returnable after 4 weeks. Mr. Moimchin, the Leonard Senior Government Advocate, accepts notice on behalf of respondent number 1. Therefore, no formal notice need be issued to the state respondents, to the state respondent. Stop. The Leonard Counsel for the petitioner shall however serve the requisite copies of the writ petition to the Leonard Senior Government Advocate within
Course of the day, your
in the
lordship.
course of
And my lord, we have an interim prayer.
in the
also.
course of the day. So insofar as the respondent number 2 is concerned, the Leonard Counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of
2 days, my lord.
2 days from today. Stop. In the interim, considering the submissions made by the Leonard Counsel for the petitioner, and also the facts and circumstances of the case, the judgment and order dated 16/4/2024,
My lord,
passed by the Dubash's court, Dubash's customary court, Seminu,
my lord,
shall remain suspended till the next returnable date.
my lord. Oblige you, lordship. Oblige you.
For motion item number 2,
Yes, ma'am.
May I please, your lordship?
Yes.
Lordship, the first writ petition was filed on March 5, 2024, which was withdrawn and dismissed with liberty to file afresh. In order to bring the document.
What is your prayer, ma'am, in the present writ petition?
Lordship, my prayer is to regularize the service of the award charge employees who has been serving the department for more than 30 years in service as
Which department?
department under the establishment of health and family welfare.
But, well, health and family.
Since
Yes,
1990,
yes, wait, ma'am. Yes. Then, they are all working under the Directorate of Health and Health Services.
yes, Lordship.
Which is correct, Department of Health and Welfare or Directorate of Health Services?
Uh, Executive engineer is the Directorate of Health and Family Welfare.
You are all serving as work charge.
Yes, Lordship.
presently,
Yes, Lordship, since 1990.
Since 1990.
Yes, Lordship. and they are eligible for regularization their service as per the office memorandum 17 March 2015.
Had MS Censor, learned counsel for the petition. Stop. The petitioners are all presently serving as work charge employee under the establishment of the executive engineer, medical engineering division, Nagaland, in the Department of Health and Family Welfare, Nagaland, Kohima. Stop. It is the case of the petitioner that all of them were appointed in service under the department in the year 1990. Where is that scheme?
Annexure 14, page 46 and 47, Lordship.
And the petitioners are therefore entitled to be regularized in service in terms of the office memorandum dated 17/3/2015, correct?
Yes, Lordship.
Issued by the Government of Nagaland Personal and Administrative Reforms Department within Brigade Administrative Reforms Branch, Nagaland, Kohima. Have you submitted any representation, ma'am?
Yes, Lordship.
Yes.
On
Let us-
17 November
Where is
2020,
that?
Annexure 18, page 54 to 60 of my writ petition, Lordship.
The page 50? Page 50?
Page 54, Lordship.
Okay. The petitioners have submitted the representation / legal notice dated 7/11/2023 to the Commissioner and Secretary, Government of Nagaland, Department of Health and Family Welfare, Nagaland, Kohima, for regularization of their service. However, the representation submitted by their petitioner has not evoked any response as of date. Stop. Being aggrieved, the petitioner is before this court. Stop. Issue notice to the respondents, returnable after 4 weeks. MS Inaholi, learned government advocate, accepts notice on behalf of all the respondents. Therefore, no formal notice need be issued. Stop. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate within
In the course of the day.
in the course of the day. Okay.
It's right, Lordship.
For motion item number 3.
May I please, Lordship? Lordship, the petitioner, my lord, he was qualified for one NIT. The reflex of the cases like this, my lord. And he was once qualified for the NIT under the FCI, my lord. But he could not execute that particular work because of certain threats to him. And after that, my lord, he deposited security deposit, and but security deposit has not been refunded, and we approached by way of representation to the competent authority.
Mr. Lund, advocate,
Yes.
is the petitioner still interested to execute the work or not?
No, no. Work has already been.
No, just clarify. Is the
Yes, ma'am.
petitioner still interested to execute the work?
No, my lord, he is no more now.
He is no more interested.
He is no more
interested.
Yes, my lord. Only but
He
he is
is only
interested in
aggrieved.
refunding.
He is only aggrieved by the actions of the respondent in cashing
Yes.
his bank guarantee.
Yes, my lord.
Correct.
That is only, yes.
In
Only, my
case
lord, by
it's
today,
back-
today I am submitting only for issuing notice to the respondents, my lord.
Yes,
to the-
yes.
Regarding refund of my this thing, money which had been forfeited from me, my lord.
Your money has been
About-
forfeited.
My money has been forfeited, my lord. Amounting to rupees 40,27,369, my lord.
That is by way of encashing the bank guarantee.
Yes, my lord.
That is by way of encashing the bank
Bank
guarantee.
guarantee, my lord. Yes. But,
Okay.
in spite,
Today we issue notice.
yes, my lord, that's all.
Yes.
Yes.
Your good name?
N. Jotendra Singh, senior advocate, my lord.
Heard Mr. N.
Jotendra Singh.
Jotendra Singh, the learned,
Senior
learned counsel, so learned senior advocate, assisted by,
Our Lordship, it's Sayyid Murtaza Ahmed.
assisted by,
Sayyid Murtaza Ahmed. It's reflected in the cost list, Lordship.
And also Meadow is there. Meadow is there, my lord, local council.
assisted by S.
Sayyid
Murtaza Ahmed.
Yes, Lordship.
And Meadow also.
And Mr. M. Solo,
Yes.
learned counsel for the petitioner. Stop. Issue notice to the issue notice to the respondents returnable after 4 weeks.
Yes, ma'am.
Stop. The learned counsel for the petitioner shall take steps for service of notice on the said respondent by registered post with AD within a period of
1 week, your lordship.
within
1
a,
week.
okay, 7 days from today. Okay.
March.
For motion item number 4.
Yes, Mr. Joshua.
May it please your lordship. Your lordship, the company of my client has been debarred by the Airport Authority of India. So, my lord, I am approaching this Honorable Court on two low points.
Yes.
My lord, your lordship,
Sana Enterprise.
my lord.
Sana Enterprise is the petitioner.
Yes, your lordship.
And Sana Enterprise is agreed by which order?
My lord, at page 81, Annexure 22, the debarment order.
Page 81.
My lord, Annexure 22. In other words, blacklisting, your lordship.
Blacklisted.
Yes, your lordship. So debarment, it amounts to blacklisting, your lordship.
Maybe you are also a black contractor.
Your lordship, I'm approaching this Honorable Court on 2 points. Number one, the debarment.
Yes, Mr. Joshua.
Yes, your
reference
lordship.
is invited to his office
My lord.
for granting the license for operating a cafeteria stall at vehicle parking area airport to MS so-and-so. The license was awarded on the basis of performance certificate dated so-and-so.
My lord.
Okay, what is the operative? On perusal of the reply submitted by MS Sana Enterprises to the above show cause notice, the personal hearing on video conferencing, the various documents submitted by MS Sana, as well as independent investigation and verification efforts by this office, it was found that the authenticity of the above cited performance certificate could not be established, and that MS Sana submitted false, wrong information documents proclaiming the experience eligibility criteria of the said facility, thus in compliance, in accordance with clause 11C of so-and-so, at vehicle parking, thus in acceptance, thus in accordance, okay, with clause so-and-so, the license for operating so and so, the vehicle parking area.
My lord.
Is hereby debarred from participating in any tender. RPF, what is REF?
RFP, your lordship,
REF or RFP, yes.
RFP.
Yeah, what is this?
RFP, I have
Debarred
mentioned
from
somewhere, but
participating in any tender RFP floated by Airport Authority of India for a period of 3 years from the date of issue of this letter, and also EMD, earnest money deposit,
yes, my lord.
submitted by MS Sena Enterprise with respect shall be forfeited. Without prejudice. Yes.
So my lord, here, two low points. In fact, the EMD is also withdrawn long back. They gave us the performance certificate also that it is satisfactory.
Who has withdrawn the EMD?
We have withdrawn the EMD because the contract period is over. Here, the illegality is on the part of the airport authority. They will also be represented, your lordship. But my lord will kindly appreciate these two low points. Number one, my lord, according to the commercial manual of 2019, your lordship, the debarment, it can be only when the contract is still alive. Here is a case where after the contract period was over, after 2 years, and after giving us all the satisfactory performance.
You are no longer running
Yes, your lordship.
that canteen.
As far as that contract is concerned, it's over, your lordship. So after 2 years, they got a complaint from some unknown entity, and we requested that such complaint copy may also be served to us.
Joshua,
My lord.
you are at present, you are no longer running the canteen.
We are running canteen here in there, my lord.
No,
But as far as this contract is concerned, it's over, your lordship. This particular contract where we are debarred, it's over.
Then why this?
No, that is why, your lordship, it is illegal in the first place. Number two, my lord, there is an arbitration clause. Article 29 of the contract agreement. So when there is an arbitration clause and the parties, this matter was pending before the learned District Session Judge Dimapur. There, the issue of arbitration came up, and both the parties agreed that we have to go for arbitration. Now, my lord, the learned District Session Judge is not empowered by law to appoint an arbitrator. So an arbitration petition is also pending here. And my lord will appreciate this. As far as the law is concerned, it is settled that when there is an arbitration clause, an arbitration proceeding is to ensue, then my lord, there can be no blacklisting. Post the arbitral tribunal proceeding, if we are found guilty, that's a different issue, my lord.
Mr. Joshua. The district and session judge Dimapur has passed any order?
Yes, he passed an order
So-
to the effect stating that he has no authority to, where's the order?
No, but parties not to give effect to the letter dated 11/9/2023.
Oh,
Ah.
yes, your lordship.
So why are you before this court?
No, my lord, we are going for arbitration. So when the arbitral tribunal is going to decide the entire issue, your lordship, then this interim order, it has to die with the,
No, that
Yes,
yes,
your
that this
lordship.
court understands.
my lord.
But presently, you also have an interim order operating in your favor, correct?
My lord,
So why the second?
no, this is already stayed in another proceeding. Civil revision petition was filed by the airport authority. Now, including this, there are 3 petitions before the Zound Court. But as far as this petition is concerned, I'm strictly here on 2 low points. After the contract agreement was over, your lordship, we were debarred,
So this
lord.
order passed by the district and session judge,
my lord.
this is pending in which revision?
Uh,
Civil revision, which?
you have the report. One civil revision petition is pending here, your lordship, but I forgot the case number, your lordship. If I may, your lordship, my apologies that I cannot remember the exact case number now. But as far as the operation of the interim order to operate beyond the closure of the main suit, my lord, I'm not even going to contest as far as this low point is concerned in that case. Because My lord is aware of the doctrine of eclipse. It goes. But my lord, here, arbitration proceeding is about to commence. That's number one, where blacklisting or debarment itself is not sustainable in law, my lord.
Just let me understand.
Your lordship.
Whether any direction has been given by this court to proceed with the arbitration process.
It's pending, your lordship, pending, your lordship. So my lord,
So
but-
when this court has stayed the order passed by district and session judge, will it not be proper for this court to pass another issue granting you interim order? I think all this can be clapped up there.
your lordship here,
That because actually like, it may not be proper for this court. Of course, I was of the view that actually like, this is the only petition, but
yes,
if there is some other petition pending, maybe I think you will have to agitate
no, my
by
lord,
clubbing up all these petitions together.
petitions can be clubbed up, your lordship.
Ah.
But, okay, if my lord, since my lord has expressed your lordship's opinion, then, let the matter be clubbed together and then I may be allowed to argue for the interim after the matters are
Yes,
clubbed up
okay.
together, your lordship.
Because I think
Oh,
it'll be proper for this court to have all the records of
your lordship, my
the
lord,
civil revision also.
my lord,
To
your
make it
lordship,
very clear.
your lordship. The civil revision, your lordship, is civil revision 17 of 2024. And the arbitration petition is arbitration petition number 3. Is it 3? 3 of 2024, your lordship.
Civil revision
17 of
and
2024, my lord.
arbitration.
Arbitration petition number 3 of 2024, your lordship.
Petition of 3.
My lord, the arbitration petition number 3 of 2024 is filed by my client, Sana Enterprise,
3 of.
2024, my lord.
So this civil revision and arbitration petition, these are listed together on the same date.
They are also not listed together. They actually they have to be, issues are separate, slightly separate, your lordship. But since it is on the same dispute, if it can be listed together, it would perhaps,
Yes, we will not pass any other. We will just direct this case to be listed with this, and you will be given the liberty to argue on the interim.
my lord,
Raise in disability.
your lordship, your lordship,
I think that will be proper. Let me not pass any other because
My lord.
actually of the tendency of the.
your lordship. Then all the 3 matters may kindly be
Yes,
listed
please.
together, your lordship.
Yes. Heard Mr. Joshua Shetty, the learned counsel for the petitioner. Stop. In the course of hearing of the present petition, it is submitted by the learned counsel for the petitioner that on the same subject matter, civil revision 17/2024 and arbitration petition 3/2024 is also pending disposal before this court. In view of the submission made by the learned counsel for the petitioner, this court deems it appropriate to take the present writ petition along with civil revision 17/2024 and arbitration petition 3/2024. All the 3 petitions may be tagged and listed together.
My lord, it may be listed in the motion so that I can argue,
May-
my lord,
It may be listed in the motion stage.
my lord,
Okay.
your lord.
Liberty is given to the learned counsel for the petitioner to argue on the interim. When the case is next listed for here, when the case is next listed.
My lord.
Listed?
Since no parties are here, my lord may kindly list it after
Any will notice be necessary?
2 weeks. Notice may also be issued, my lord,
Listed after 3 weeks.
my lord, your lordship.
In the present writ petition, the learned counsel for the petitioner shall take steps for service of notice upon the respondents by registered post with AD within a period of
2 days, my lord.
within a period of 2 days.
Hello.
from the listed according. Okay.
Oblige, your lordship.
For motion item number 5.
Yes,
May I please, your lordship?
yes, ma'am.
Your lordship, the petitioner is aggrieved by the deduction of 16 months' salary from his pension gratuity amounting
Where
to,
is that impugn order, madam?
your lordship, the impugn order as is at page number 36 of the petition,
36.
and extra 10.
Overstay of the. You have overstayed in service?
Your lordship, the overstay in service was not due to any fault or misrepresentation on the part of the petitioner, but it was due to the negligence on the part of the department.
Overstay for 16 months.
Yes, your lordship.
Any deduction made?
Yes, your lordship, the deduction has also been made.
Where have you stated? But let us see your prayer. Let us see your prayer. Let us see.
Your lordship, the prayer is at page number 14.
14. Any deduction continuing?
No, your lordship.
Deduction is
Deduction has already been made.
already been made.
Yes, your lordship, from my pension gratuity. Your lordship, all along, the department has taken my date of appointment as 1st April 1989.
So your grievance now is to refund.
Yes, your lordship.
MS so learned counsel for the petitioner. Stop. The present writ petition has been filed by the petitioner, seeking for a direction to the state respondents to refund/pay to the petitioner, refund pay the amount of rupees 9,74,010.
310.
310.
Yes, your lordship.
Which has been deducted from the pensionary/retirement benefits of the petitioner. In terms of the order dated 29/9/2023, passed by the director, passed by the director, Government of Nagaland, Directorate of Youth Resources and Sports, Nagaland, Kohima. So, from the order, it is seen that the deduction was made for overstaying in service for 16 months with effect from January 2022 till May 20.
Your lordship, with effect from February 2022.
With effect from February 2022 till May 2023. Okay, stop. Issue notice to the respondents, returnable in 4 weeks' time.
My lord, as far as the office of the AG is concerned, we have already received the copy. I'll be seeking instruction from my client's lordship. Respondent number 5.
Okay. MS Pichano, the learned government advocate, accepts notice on behalf of respondent number 1.
1 to 4.
Accepts notice on behalf of the state respondent number 1 to 4, and Mr. Joshua Shaki, the learned standing counsel for the respondent number 5. That is Accountant General. Accepts notice on behalf of the state respondents. Stop. Since all the respondents have accepted notice, no formal notice need be issued to the said respondents. The stop. Learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned counsel for the respondents
In the course of the day.
in the course of the day. Okay.
Your Lordship.
For admission, item number 6.
May I please, Your Lordship? This matter is regarding the retrospective regularization, and Lordship, similar matter is pending before the divisional bench. So Lordship, if this matter will come up after the disposal of this writ appeal.
Read appeal. I think this pending before the Honorable Supreme Court.
Lordship,
Yes,
Lordship,
Mr. M.T.
Lordship.
Before the Honorable Supreme.
Yes.
MS. Pichano. The learned government advocate submits that similar matter is pending before the Honorable Supreme Court of India. Stop. The present case may therefore be listed on disposal of the case by the Honorable Supreme Court of India. Okay. Yes.
Are you pledged?
For admission, item number 7.
May I please, the Lordship?
Yes, Mr.
My lord, here I'm appearing for respond number 6 and 7.
6 and 7.
Yes, my lord, I'm yet to receive instruction.
6 and 7. Who are 1, 2, 3, 4? 1, 2, 3, 4, 5.
It's YP Gupta.
YB Gupta.
Yes. So my lord, kindly allow me 3 weeks time, my lord.
This YP Gupta is continuously seen absent. Whether 1 to 5 has filed affidavit?
No, Lordship.
Who is the man respondent to file affidavit?
1 to 5, my lord.
What is the matter?
Lordship, here I'm aggrieved with the eviction notice. Eviction notice.
Eviction notice. You are on a railway lane.
They have
You
said
are
that it's
occupying
a,
a railway lane.
Yes, sir, yes.
they have said that it's a railway lane, but
Mr. Ejmomi,
No,
you are occupying a railway lane.
Not at all, my lord. So it is private land and the railway assumes that it is railway land.
You have all this land.
I have all the documents and we have been in possession since ages. This is the KV Zakisaro colony, your lordship, in Dimapur.
Oh. 1 to 5. So it is a 1 to 5. Who should be answering the writ petition?
Yes, ma'am.
Yes.
Correct?
Yes,
The eviction notice was issued by 1 to 5.
Yes, ma'am.
yes.
My case is this, your lordship, simply, this is private land. Railways cannot resort to the process of eviction under the Public Premises Act.
Okay, we pass an order stating that if on the next day the affidavit is not filed, we dispose on the.
Yes, my
matter.
lord. Yes, ma'am.
Heard Mr. H. Momi, the learned counsel for the petitioner, and Mr. E. Tibapong, the learned government advocate for the respondent number 6 and 7. None appears for the respondent number 1 to 5. It is submitted by the learned counsel for the parties that it is the respondent number 1 to 5 who should answer the writ petition by filing the affidavit in opposition.4 weeks' time is accordingly granted to the respondent number 1 to 5 to file the affidavit in opposition. Stop. It is made clear that if no affidavit is filed on or before the next date fixed, the writ petition shall be disposed on the basis of the materials available on record. Okay? Okay.
Much obliged, my lord. There's an interim order. If the interim order can continue.
So the interim order passed earlier shall continue till the next returnable date. Okay, have we given the date? 4 weeks, no? Okay.
Much obliged, much obliged.
For admission, item number 8.
May I please, your lordship?
Yes, ma'am.
My lord, here I'm yet to file affidavit in reply to the counter filed by the state respondents. My lord, kindly grant 2 weeks.
MS, your good name, Chris.
Give Christine.
Senior,
Yes, my lord.
the learned counsel for the petitioner, for 2 weeks' time to file an affidavit in reply. Where is allowed? Listed according.
For admission, item number 9.
Yeah, please, your lordship.
Yes.
Lordship, we are yet to file an affidavit in reply. Can you grant 2 weeks time?
Also for the petitioner, your good name,
Imtichang.
Mr. Im Chang, learned counsel for the petitioner, for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Where is allowed? Listed accordingly.
For admission, item number 10.
Yes, Mr. Subo.
Yes, Lordship, I have received the counterfile by the respondents. So I pray that I may be granted 4 weeks time to file a reply, Your Lordship.
Mr. Supumwati Wali, learned counsel for the petitioner submits that he has received the affidavit in opposition filed by the state respondents, and he would require 4 weeks time to file reply, if so advised. Where is allowed? Listed up to 4 weeks.
Bless, Lordship.
For admission, item numbers 11 and 12.
Yes, ma'am.
May I please, your lordship? Pleadings are completed. May this matter be listed after 2 weeks for hearing in usual course.
Okay,
Lordship.
who are the parties? Let me first see this. Okay. It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be listed for hearing. Stop. Listed for hearing in the usual course.
I oblige, lordship.
For admission, item number 13.
I may be, yes, I want to file an affidavit in reply, we may give 4 weeks
Oh, to
to the counter of the state
state.
respondents. Yes.
Okay. Mr. L. Iralu, the learned counsel for the petitioner, 4
4
weeks time
weeks.
to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed accordingly.
There's an interim.
The interim order must shall continue on the next.
Much obliged.
For admission, item number 14.
Yes, Mr. Sobo.
Yes, my best, Lordship. Pleadings has been completed, Your Lordship. So I pray that the matter may become on the usual hearing list.
Lordship.
Only the state is a party responding.
Lordship.
It is submitted by the learned counsel for the parties that hearings are completed and the matter can be listed for hearing. Stop. Listed for hearing in the usual course.
I oblige.
For admission, item number 15.
Yes.
Yes, yes.
Same thing,
Your Lordship, by the order dated 24/9/2024.
24/9.
Yes, no, respondent number 5, that is a Secretary, Minister of Urban Development, Government of India. So unless the respondent number 3 activated, the matter cannot be proceeded.
Government of India is respondent number.
Number 5.
My lord, I was told that the plating is completed.
Pardon?
Plating is completed.
Yes, Mr. MT, what?
I think respondent number 5, they have not yet filed an affidavit in the motion.
They have filed an affidavit.
They have filed.
Wait, five.
Okay.
Right?
So pleadings are completed?
Yes, my lord.
The matter will be posted to hearing, my lord.
So we listed for hearing, same thing.
Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be listed for hearing. Stop. Listed for hearing in the usual course.
Lordship, if Mr. Kekringulia's name can be expunged from the cause list.
The name of Mr. Kekrimuli as the learned counsel for the petitioner
Lordship.
is ever deleted from the case. Registry to take steps accordingly.
For admission, item numbers 16 and 17.
Yes.
My lord, this case also pledging is completed, so let this matter be posted for hearing.
Union is the only party.
Lordship, here
Yes.
pleadings are completed.
That's why I'm asking union, whether union is the only party.
Yes, my lord.
It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be listed for hearing. Stop. Listed for hearing in the usual course. Okay.
For admission, item number 18.
May I please, your lordship?
Yes, ma'am.
Your lordship, I'm on behalf of Mr. Sentianger as he's out of station due to some personal reasons. For item,
Madam, you still have to file your reply for them.
yes, can you please grant 2 weeks to file
We will
reply?
give you, we will grant you that. Your good name,
Yuka Kokla.
MS. So and so. Learned counsel makes a mention on behalf of Mr. Sentianger. And learned counsel for the petitioner and seeks the adjournment of the case for 2 weeks to file affidavit in reply. Fair result, listed accordingly.
Obligement.
For admission, item number 19.
Yes, Mr. What happened to this case?
Could not be taken up, your lordship. Now, lordship, my senior, Ms. Nuksantila is on her legs in the other courtroom number 3. She's present.
That IE is still pending?
It is still pending, your lordship. And if your lordship will recall, the 226(3), that issue was kept open. Now that issue has been decided by a constitution bench, your lordship, by of the Honorable Supreme Court.
Okay.
So no more, yes,
Resent.
yes, my lord, no more res integra. So 226(3)
Do
would
you have
apply.
the copy of the order?
I do, my lord, but I don't wish to take advantage of her absence.
Okay. So what do we do?
She's here.
Some other time, say, remove it, not because maybe this court will be handicapped after 1.
They're on Monday, my lord.
We can.
Monday, man. Monday is fine,
Okay, Monday.
my lord.
Listed again on,
Monday,
what is the date?
21st.
21, 10, 20, 24. This is for hearing on the IA.
IA, my lord, yes. Much obliged.
For admission, item number 20.
Same.
No, my lord, this is about whether the Dubashi's court has appellate power sitting in appeal over the
20.
21, my lord. 21.
So this, the
21.
IA 102. Same order in 20. Same order.
No, we are in 21 now, my
No,
lord.
no, no.
Same order in 20.
Same order 20.
Yes, my lord.
Same order 20.
Yes.
This one. And this 21 is? We are now on 21.
Yes, my lord.
Your lordship, here by the order dated 10 September 2024.
10 September. Yes, 10 September 2024.
I was instructed to place one judgment.
10 September 2024.
Yes,
Ah.
your lordship. Your lordship, here on the same issue, the your lordship has passed one judgment in WBC 164 2017. by the judgment and order dated 19/6/2023. So in that judgment, para number 2, the judgment explained about the issues of the effect. And para number 3 is about the effects, and para number 3
Para number 3 is facts.
facts. And Your Lordship, in that judgment, para number 3, clause 6.
Para number 3.
Clause 6.
Yes, wait, Mr. MT. Para number 3, clause 6.
Clauses, that is page number 3.
Yeah, page number.
So there also it has been mentioned that the pursuant to the representations submitted by the petition.
No, this affects, where's the operative portion?
That is page number 3. Page number 3 of the judgment.
Page number 3, Mr. MT. Page number 3 is.
Operative
the fact.
portion is
Is the fact.
yeah, clause 6 is a fact, but it has again emphasizes about the
The respondent is in view of the passed by the honorable division bench. So far as it relates to question of the Vice Court exercising appellate jurisdiction.
At page 5, Your Lordship, the operated portion, page 5.
Page
paragraph
5.
Yes.
Page 5.
Paragraph Roman 10 and down below at
Just wait, Mr.
clause 6.
Paragraph
5.
Page 5.
Page 5, Roman 10,
Roman
10,
page 5, Roman. Okay.
in the middle of the page, and at the bottom A.
Just wait.
At the bottom A. At the bottom A, as to whether any decision passed by the village council court can be heard and appealed by the Dubashi's court, even if the same is referred to it by the deputy commissioner and the additional deputy commissioner, assistant to the deputy commissioner under Rule 23A of the rules for administration of justice and police in Nagaland 1937, and B, as to whether the office of the EAC can be equated with the office of the assistant to the deputy commissioner. We are not so concerned with this, Your Lordship. But paragraph, then Roman 12, next paragraph. Subsequent to the order passed by the Honorable Chief Justice to place the matter before the available division bench at Kohima, the question of reference was heard by the Honorable Division Bench, and by the judgment and order dated 4/12/20, answered the reference by holding as follows: the Bashis cannot be empowered as appellate court by the exercise of powers under Rule 23A. Rule 31 debars DCs and ADCs and his assistants from such authority. So the Bashis court has no appellate authority.
So
That
what
is
is the facts in your?
So, Your Lordship,
Facts.
in my synopsis, it's very short facts, Your Lordship. Everything is mentioned in my synopsis. Respondent number 5, that is a private respondent, submitted an application dated 29/12/21 to the village council of Haushe village, claiming a land dispute between him and the petitioner. By a letter dated nil, the village council informed the respondent number 5 that it is not aware of the claim put forward by him and returned the application. The village council thereby rejected the application of the respondent number 5. Thereafter, the respondent number 5 filed an application dated 23/8/22 against the decision of the village council before the deputy commissioner New Land. The deputy commissioner New Land endorsed the application to the SDO Civil New Land. Subsequently, by letter dated 26/8/22, the SDO Civil endorsed the matter to the Dubashi Court New Land. By summons dated 30/8/2022, the parties were directed to appear before the Dubashi Court New Land on 13/9/22. On this date, the petitioner appeared and objected to the claim of the respondent number 5 on the ground that the Dubashi Court had no jurisdiction to entertain the application filed, and that entertaining a claim after more than 50 years is impermissible. By a settlement dated 28/11/22, the Dubashi Court New Land held that the respondent number 5 is entitled to the immovable properties of his late father situated in Hauptstadt village. Against the decision of the Dubashi Court, the petitioner filed an appeal dated 19/12/22 before the Deputy Commissioner New Land. However, till date, no process have been issued pursuant to the filing of the appeal. This is the case, madam.
What about a notice on respondent number 5?
We filed an affidavit of service, Your Lordship, and in my affidavit of service, which was filed on 13/8/24, we have,
Just wait, Mr. No, 13/8/2024.
yes, my lord. And the affidavit of service at paragraph 3. At paragraph 3, I have stated the facts surrounding my attempt to serve a notice on the respondent number 5. He refused to accept, my lord. So refusal actually amounts to receipt of notice.
Okay, just note down, Mr. A. Jimomi, learned counsel for the petitioner, and Mr. Im Timso, learned additional AG Nagaland for the state respondents. None appears for the respondent number 5 despite notice. Okay, we pass the order.
Very well, madam.
We pass the order.
Much obliged.
Oh,
For admission, item number 22.
May I please, my lord?
Yes.
Lordship, Lordship, may kindly grant me a week time to find my counter affidavit, my lord.
Mr. Taka, what is the case?
My lord, the simple issue is, my lord, whether in the advertisement for fourth grade appointment, preference to the landowner should be, clause should be drawn. Now, it is already governed by a lordship judgment in WC 123. In fact, on the last occasion, the direction was to receive instruction as to whether your lordship judgment will cover the present case. We came to, before there's a noble court, there was a direction to advertise the post.
If I remember, in one case, it has been withdrawn. No?
Exactly that case, WBC 123. So,
Lordship, the case that has been referred to and has been stated that it is a covered case. In this particular matter, your lordship, it is actually not a covered case because, your lordship, there in the order passed by this honorable court, there was a categorical order that the land ownership issue also has to be advertised. While advertising it, preferences should be given to that particular statement also has to be there in the advertisement.
Mr. Taka, kindly clarify whether you were a party in that earlier writ petition.
No, we filed a separate writ petition.
Analogous. Is it?
Yes, 5 analogous matters. In fact, lordship, the 28th August 2024's order clearly explains the position. In this court.
Have you annexed?
No, my lord, his orders. My lord, the copy of the order 123 is before lordship. It was already placed. But if your lordship may kindly see the last order passed on 28/2024.
28.
Yes.
Yes, yes.
Because lordship, the judgment was in my case, lordship, the judgment was passed by Honorable Justice Silo. Then fortunately, the petition was moved before him. So the issue was, direction was to advertise the post in accordance with the office memorandum. So when he says in accordance, yes. So when he say in accordance with the office memorandum, obviously the office memorandum of 2000 indeed talks about preference to landowners.
Yes, Mr.
Lordship,
because if your lordship,
yes.
Ultimately, that it boils to that because it is not necessary to include everything. But when the court says it advertised in accordance with the office memorandum.
In fact, your lordship, the order, if I may be allowed to read the order passed by this honorable court in the previous writ petition filed by the petitioners hearing, your lordship, the orders, in fact, at para 19, the order was to go for an open advertisement.
Yes.
Was to go for an open advertisement? Yes.
Preference to the landowners.
No.
That also is to be mentioned.
No, it is not there. It is not there.
If your lordship may allow me to read his judgment. But since if he is filing affidavit, let him file.
Yes.
Then lordship, or on the basis of instruction can be disposed of also.
No, your lordship, we are filing.
You're
filing, your lordship.
File it.
Yes.
I think it should not prolong.
Yes, just a week time. We require just a week time, your lordship.
Mr. Enangami, the learned senior government advocate is granted a week's time to receive instructions and to file.
My lord, he must have received
No,
instructions.
your lordship, yes, I have already received instruction. We are just filing.
I'm sorry, Mr. Enangami, the learned senior government advocate submits that he has received instructions and will be filing the affidavit in opposition within a week's time.
Lordship.
And therefore seeks adjournment of the case for a week. Prayer is allowed, listed accordingly.
If your lordship may kindly give me a date, give us a
Listed
date.
accordingly on. Suggest on.
Let him suggest, since he's praying.
You take some boxes. Listed on.
If my respectful submission, my lord,
Please.
let him file within the period of 2 weeks, 1 week. Then I may be given 1 week's time to file reply accordingly, then matter will be listed in the month of November.
What was that order? What was that order which will, please read, ma'am? Please read.
And who will file the affidavit in the position, begin at this time, and therefore seeks adjournment of the case for a week.
Okay, wait, okay, and therefore. The government advocate shall file the affidavit in opposition as submitted. And Mr. Takamasa, the learned government advocate.
No, not government.
The learned, I'm sorry. The learned senior advocate shall file the reply, if so advised, within said period of 2
1
weeks.
week, 2 weeks, lordship.
2 weeks. Listed on.
My
Take
lord,
2 weeks.
yes, let it be then. Let it be on 5th November.
Listed on 5/11/2024.
Much obliged, lordship.
Deeply obliged, my lord.
For admission, item number 23.
At least your lordship. Lordship, here I'm here to receive instructions, so I may be kindly granted some time, your lordship.
Lordship, yes.
Miss, have you also filed?
No,
You also
yet to
report
receive
that?
instruction.
MS Inauli, the learned government advocate, as well as MS, their good name,
Honbeni Izung,
so and so.
Ojo
Learned
Shashike,
counsel for the respondent number
5, on behalf of.
are both allowed 2 weeks' time.
3 weeks.
Are both allowed 3 weeks' time to file their respective affidavit in opposition listed accordingly.
Much obliged, your lordship.
For orders, item numbers 24 and 25.
Please, lordship. My lord, here we are yet to file our affidavit in opposition.
You are for the respondent,
For respondent number 1, my lord.
for respondent 120.
So, my lord, I pray that, my lord, 3 weeks' time may be given.
What about this for
Your lordship,
CEO?
I am here. The main counsel.
No, no. What are you?
Till last date, my lord, for respondent number 4, notice is yet to be served on respondent number 4.
You have not served notice?
Yet to be completed, my lord.
Yes. Fresh steps for service of notice upon respondent number 4 has not been taken. You have not taken fresh steps?
I have taken your lordship.
Oh, 1410,
Yet to be completed.
1410, 1410 order, 1410 office noting shows that you have not taken steps. Have you taken steps? You have not taken steps?
I will comply that, your lordship.
Comply, please comply, okay? 1410. You take fresh steps, okay?
Yes, your lordship.
Mr. So-and-so. The learned counsel for the
Respondent number 1, 2, and 3.
counsel for petition shall take fresh steps for service of notice.
Interim may continue, your lordship.
Just wait. Upon respondent number 4 by registered post week AE within a period of
3 weeks.
no. For taking steps. Fresh steps
5 days.
within a period of 5 days from today. The learned counsel for Mr. Your good name,
Yes, my lord.
so and so.
Respondent number 1 to
The
3.
learned counsel for the respondent number 1, 2, and 3. Is granted 3 weeks time to file affidavit in opposition. Listed after 3 weeks. You take steps, okay?
Yes, Your Lordship.
What was the, KB, what was the first para? Shall take fresh steps for service of notice. Shall take fresh steps for service of notice upon respondent number 4 within a by a registered post within a period of 5 days and file affidavit to that effect. At that. Okay? So you take steps and file affidavit.
Yes, Your Lordship.
Okay.
Interim may continue, Your Lordship.
The interim order passed earlier shall continue till the next returnable date. Okay.
Much obliged, my lord.
For orders, item numbers 26 and 27.
May I please, Your Lordship, on
Yes.
behalf of M. Longomer, the state is here to receive
M.
instruction.
Longcomer.
Lordship,
Who is M. Longcomer?
Mosom,
26.
Lordship,
Lord, I'm praying for the petitioner.
Also.
Yes, I'm for private respondent, but my name is not reflected. So if my name is
Private
reflected
respondent number,
for, in one case, I'm for respondent number 4 and private respondent 4, and then other one is in for 6.
have you filed your affidavit, Mr. Timjan?
No, not yet, Lordship.
Lordship, the state is here to receive instructions, so kindly grant 3 weeks time to file affidavit.
You have not filed your affidavit?
Lordship.
You have not filed. MS Chano, the learned government advocate, as well as Mr. Timjan, S. Timjan,
Lordship.
learned counsel for the private respondents are allowed 3 weeks time to file their respective affidavit in opposition. Okay.
For hearing, item numbers 28, 29, and 30.
Yes.
May I please? Lordship has difficulties after 1?
Yes, because I want to attend the hospital at 1.
Lordship.
Yes.
If that is the case, your lordship, can we take up the matter on Tuesday at 1 stretch, your lordship?
Next week.
Next Tuesday, because Monday lordship has fixed one part heard matter, hearing matter.
Next week, maybe it may not be
Or we can try if it is not possible today, tomorrow.
tomorrow, no. Tomorrow at
So-
least 6 minutes.
So Tuesday or Thursday. as per-
We take a chance on Tuesday.
Lordship.
If possible, we take up, if not,
Lordship.
maybe. Because,
Monday, there's one part heard matter.
yes, I don't want to take so much of a part heard case or so much of reserve case during my holidays.
Lordship.
I think one should suffice.
Then we can try on Tuesday, your lordship, if it is
Tuesday.
convenient.
What is Tuesday?
That Tuesday will be 22nd.
Listed as a part of the item again on 22/10/2024.
Lordship.
We give a try.
Lordship.
We give it.
Lordship, obliged.
Much obliged.
Yes. But have you compiled?
Yes, my
Have
lord.
you compiled?
Yes, I've come.
I think whether it is before me or before.
Yes,
I
yes,
I
yes.
think-
I've rectified, my lord.
Thank you, thank you.
Okay.
For hearing, item number 41.
Yes, ma'am. 41.
Kindly let the matter be listed after 3 weeks.
Why? What is the reason, ma'am?
Since he's out of Mr. Sentianger is out of station.
Your good name?
Yukakokla.
MS so-and-so. Learner Council makes a mention on behalf of Mr. Sentianger, Learner Council for the petitioner, and seeks adjournment of the case for 3 weeks. On the ground that Mr. Sentianger, the Learner Council for the petitioner is out of station. Where is allowed? Listed at home. Okay.
For hearing item number 43.
Yes.
Please, Your Lordship.
Yeah.
Lordship, here, the petitioner is praying for appointment on compassionate ground, my lord.
Have you filed your reply?
Lordship,
Lordship, they have filed their counter and I will not be filing my reply, my lord. And as per the affidavit filed by the state, I'm placed in serial number 17, my lord.
So you have a chance.
Yes, my lord. So Lordship can pass a notice. As and when my turn comes, my case should be.
Where is that?
annexure batch number 5, Lordship.
Page 5. Page 5, Eviction.
Lordship,
Eviction.
Lordship.
Yes, my lord.
Serial
Late
certificate.
Ivika. Yes, my lord.
List
And
of applications for compassionate appointment. So on the basis of this, we can dispose, we can give a direction as and when your turn
Lordship.
comes.
yes, my lord.
Correct?
Yes,
Yes.
my lord.
Okay.
So, Lordship, the only clarification is here, serial number 17, it was, the representation was first submitted by one T. Zakalu. He's the brother of the deceased. But then again, it was replaced by one Miss Akali, who is the wife. So now the wife is seeking for the appointment. It is the wife who is seeking for the, that's late Kivika. Deceased. Yes, yes.
Name of the applicant is T. Zakalu.
Yes, my lord, but T. Zakalu was replaced by one Miss Akali, who is the present writ petitioner, my lord.
In 17 below, you will find replaced, Lordship.
Just below that, my lord, below serial number 17, it's written replaced, my lord. So,
Replaced by-
yes, by Miss Akali, who is the present writ petitioner, my lord, who is the wife of the deceased.
That doesn't make any difference. You are in serial number 17.
Yes, my lord, just a clarification since there are two representations in the writ petition, my lord.
What is your case in fact?
My lord, the petitioner's husband died in harness, my lord,
Let's see
on
the-
10/5/2020.
Petitioner's husband was working here. Petitioner's husband died in harness on 10/5 while working as
Khalasi, my lord.
Alas.
Yes, my lord. He was appointed in the year 2012.
Then
So he died in harness and the death certificate is
so
at page
when
15, my
did
lord.
did you submit your application?
My lord, 9/11/2023. It's at page 20, my lord.
Page 20.
Page 20 is my representation, my lord.
Okay.
Praying for appointment on compassionate ground.
Page 20.
Page 20. It's dated 9/11/2023, my lord.
It's dated 9/11/2023.
Yes, my lord.
Okay. Okay, so that is only, and this was not considered, so you have.
Yes, my
For commissioner appointment, you have been shown at serial number 17.
Yes, my lord.
And therefore, your submission, your submission is that the matter can be closed.
Yes,
Give
my
this
lord.
direction to the state respondent to appoint the petitioner in terms of the list of applications.
Yes, my lord. That is my prayer, my lord.
Okay, we pass the order.
Okay.
Heard, Mr. MS Lucino. Learner Council for petitioner. And Mr.
Ajumli,
Your good name?
Ajumli Samdam.
Your, okay, and Mr. Adjournment Santam, the learned government advocate for the state respondents. Okay, we pass the order in the chamber.
Much obliged, my lord. Much obliged.
Also give this in the chamber.
Yes, Lordship.
Disposed.
Obliged, my lord.
Done.
Menjadi jawaban. Menjadi. Number 43. 43, Karijimo. Item number 21. Menjadi. H. Allah.